Okay, hello everyone. I'm Patricia Shampton with the Texas Exes, and thank you for joining us for our March Lunchtime Lecture. And thanks to our sponsor, UT Austin's Extended Campus. Extended Campus offers a variety of graduate programs, professional certificates, and skill building courses to support your career goals no matter where your next step is. And among these offerings is the Human Dimensions of Organizations program, which provides interdisciplinary education focused on understanding the human elements of organizations. Texas Access members also receive a 10 to 25% discount on non-credit professional education courses. You can learn more at extendedcampus.utexas.edu. And today we're very excited to welcome Dr. Mary Rose to teach us about America's jury system. Dr. Rose is a professor in the UT Department of Sociology and the director of the Human Dimensions of Organizations program in the College of Liberal Arts. She received her bachelor's from Stanford and a PhD in social psychology from Duke University. And her research examines lay participation in the legal system and perceptions of justice, and she has written on a variety of topics, including the effects of jury selection practices on jury representativeness and citizens' views of justice, jury trial innovations, civil damage awards, and public views of court practices. She served on the editorial boards for several law journals, and her research has been cited in United States Supreme Court cases. Today, she is here to debunk the commonly held idea that American jury system is in charge of decision-making in our criminal justice system. We will learn the ways the country has allowed the jury system to wither and the challenges to shoring it up. So thank you very much for being here, Dr. Rose. Take it away.
Thank you so much. It is absolutely a delight to be here. And I've already been introduced, so I don't really have to say a whole lot more. I am a professor in sociology, and I am very proud to direct the Human Dimensions of Organizations program, or HDO. We have both an undergraduate degree and then a master's program, one of those sort of exec ed style master's programs. So it's very delightful. I've been teaching in that for many years. So I just am very excited at the invitation. I could talk about juries all day long. So I had to think of what I wanted to talk about with y'all and what I wanted to focus on. And I threw out a title like this, Is America's Jury System Losing Its Power? And the answer, of course, will be yes, but it will be hopefully explaining why we have something like this in the first place, what advantages it has, and what we do give up on when we allow the jury system, as Patricia said, to wither. All right. During the Cold War, you would find an awful lot of kind of pro-America, anti-Soviet Union propaganda posters. And this is one. It would, focus on the Bill of Rights, and it would give attention to something we all think of when we think about the Bill of Rights, which is, press freedoms, or it might have been religion, or free speech, etc. And, these were posters just reminding people to care about these things and to not take them for granted. They did produce a poster about trial by jury. This is actually a picture of one hanging in my office, to mention that same Bill of Rights protects this right to trial by jury. And I'm always struck by this poster because I, first off, am not sure that people recognize the ways that the trial by jury right was embedded in the Constitution, and how central it was seen at one time to protecting our liberties. So I thought I would just kind of start there by talking about the jury in the Constitution. So if you recall, there was sort of this two-phase process of having the first round with the Constitution and then having the Bill of Rights, or first 10 amendments. So in the very first round, when they were setting up Article 3, which governs the judicial branch, Section 2 had some very strong language in it, which is that the trial of all crimes, except in cases of impeachment, which we all know is a political matter, shall be by jury. And then they made sure that people knew that this would these jury trials would be held where the crimes have been committed, so that the powers that be wouldn't, pluck somebody out of their community as a defendant and move them off to another state or another district or another area. In order to get a good verdict that you had, someone committed a crime in a particular community, that was where the trial was supposed to be. But what I'm struck by in this is the shall language, so that it was really not a lot of room for discussion there. And so this is kind of how the main body of the Constitution went forward. And when it was amended, there were several things that were made very clear within the Bill of Rights. So first, the Fifth Amendment mentions a grand jury right, and this was put in there on the idea that it's if the state is going to charge someone with a crime, one of the most powerful tools it has in dealing with citizenry, that they have to present the basis for the charge to a group of lay people, to a group of citizens. So grand jury simply means it's bigger in size. Nowadays, they're in the couple dozen size. And the idea is the state is and the government are supposed to be able to say out loud to this group why they are pursuing these charges. And you can imagine why the founders would be concerned with this, so that, again, people were not kind of plucked off the street, particularly if they were political enemies. And put in prison where it's very convenient to have them away and out of sight, out of mind, so that you had a right to have these this situation and these charges reviewed by the community. Then the Sixth Amendment is what we often think of when we think jury, which is a criminal jury, and what is called, in contrast, a petit jury, and that is a 12-person, at least at the time, a 12-person jury that is designed to decide whether the state has proved its case beyond a reasonable doubt. And they did say in that amendment that you have a right to a jury, which vests the defendant with a choice, that they can also have a judge. So they kind of played with the language and made it a little less all or nothing. And then the Seventh Amendment is where we see the right to a civil jury in a civil trial. And they fudged with the language, but basically said that the rights you have shall be preserved for this. And they specified, what amount of money has to be at issue, so not a small claim. But that basically they were preserving the right to a jury in this setting. So I just want to stop here and say that when you think about the Bill of Rights, 30% of them mention the word jury and are concerned with the idea of the government in particular, but also in these private disputes, having a body that represents the community have some say in these procedures. So you can see that this idea held an awful lot of appeal to people working on our early constitutional documents. And basically, this was a group of people who were particularly concerned with tyranny and concentration of power. And so, what is it about the jury that was appealing in that it was guaranteed in the Constitution? And I will say, other countries have jury systems, but we are kind of unique in making it very hard to get rid of it formally. Congress cannot pass a law and say, I don't really like juries to be hearing libel cases, so they can't hear libel cases anymore. Or I don't really want juries to hear a kind of traditional armed robbery cases, because we would like those to move along more quickly. So we're going to take the jury trial right away from them. Other countries can do that, but we cannot. And I'll say how we get around that. But in the main, we can't pass laws that say for these particular class of crimes, you can't have a jury at all, ever. And that's because the jury was particularly appealing to people. It was highly traditional at the time of the founding. It had been in some form or another for literally centuries in Great Britain. And that it had also been tested through court cases in which it was established that if a jury rendered, say, an acquittal in particular, they couldn't be punished for that verdict, and that this couldn't be a case of the king just saying, oh, wrong verdict, try again. And so the notion of the citizens having this kind of final say on whether criminal charges have been met was very appealing to people concerned about the concentration of power. It's appealing because most basically juries do not work for the state. So, and that is not true of judges. They may be a separate branch, but their paycheck comes from the government and they're government employees. And so the jury represents a body, and anyone on this call who has served on a jury knows you don't get very much money for serving on a jury. It's really not a pay so much as a stipend that might cover parking and might cover your lunch. So you are not financially incentivized to side with one player or another. And you are what sociologists of law like to call a non-repeat player. You are not coming back again and again and again. And there are some advantages to being a repeat player, but there are some disadvantages in that, cases start to sound alike to you. You've heard it all before. Oh yeah, I love it when defendants talk like this, because 5 cases ago, this is what happened. Instead, you are coming at a case with very fresh eyes and a fresh perspective, notwithstanding that you may have been on a jury before. And that, even among those who are serving on juries, they are not elites. The phrase jury of your peers does not appear anywhere in the Constitution. That's kind of an idea that we've adopted and talk about juries. But to the extent that it appears, that concept appears in the Constitution, it means that the juries appear to the defendant in the sense of not of being a fellow community member. They are ideally from your community, and or at least where you chose, if you were charged with a crime, where the crime was charged. But you are not a high and mighty judge, and judges do occupy a very elite position. When I teach this to my students, I have them think through what it takes to be a judge in modern America, which is an undergraduate degree and then a law degree. And if you're going to be particularly on the federal bench, you better have gone to a really nice undergraduate and law school to be competitive for those positions. And even certainly at the state level, you need to be someone who has definitely earned the trust of voters in Texas, where we elect judges. And so you are a very unusual person compared with the average citizen. And so I think there's an appeal to vesting power with people who don't have to go through all those hoops. And then obviously as a decision-making body, you are getting multiple perspectives on the facts of the case, as well as their views about whether the state has met its burden. So it isn't up to a single individual. It divides responsibility across many people. And that is, again, spreading power and decision-making responsibility. So the implications of this power are that you see again and again the way juries check each branch of government. So most basically, a jury is a check on the state's power to lock up people, and particularly, of course, political enemies or anyone that you would see as the state abusing its power. And so that both through the grand jury right and the criminal jury trial right, the state has to answer to the people in terms of whether it has a reasonable basis to go forward with the case. And here I should pause and say that this was a federal protection for the grand jury. There are states that don't have grand jury systems. But all states have the petit jury, or the Sixth Amendment jury. And so that it is a check on state power to just kind of pluck people off the streets. It's an insurance that judges who are, again, employees of the state, who are elite, do not have total control over legal decision-making. We certainly vest judges with an awful lot of responsibility to decide procedural issues and what the law is and instructions and all of that, but the actual decision-making, we have this alternative through the jury. And then finally, juries are a check on the legislative branch, because you can have an instance in which the legislature passes a law that everybody thinks is awful. And it becomes, in that case, it becomes very hard to get a conviction or to see juries act on civil matters if the law is so very much out of step with their own viewpoints. So famous historical examples would be it was hard to get a conviction in the North against the fugitive slave laws because abolitionists didn't respect the law and weren't going to honor it. And so all of these checks mean that there are scholars who see juries and have dubbed juries the fourth branch of government, or alternatively, others who aren't willing to go quite that far see them as the lower house of the judiciary. So in the way that on the legislative side, you have the upper chamber with the Senate and the lower chamber with the House. Juries are the more populist part of the judiciary. So this is just, I don't think we always think about the roles that juries serve, but when you kind of stand back and see what the vision was and all the ways that they check power, it's quite remarkable. So now I'm going to talk about the not having so much power anymore thing. And before I do that, I do want to make sure for any historians on the call that I'm clear about the fact that juries, I don't want to imagine some past time where the majority of all cases were going before juries and that the majority of all civil trials were being decided by juries. There's never been a point where they have been the primary or majority legal decision maker. One estimate of sort of the 1820s to 1920s from an exhaustive review of like court records in some areas estimate that between 25 to 30% of all civil juries cases were resolved. Sorry, of all civil cases were resolved by jury trial. It's always been the case that most, and a majority, so above 50% of criminal cases have been decided by some form of a plea. So what I'm going to be talking about here with slides and data and stuff is not that, again, there's some imaginary past. What I'm going to try to impart upon you is just how extreme the imbalance has become and how rare the jury trial has become. And that is actually reflecting how rare trials have become. So this isn't only a jury issue, but juries are obviously bound up in trials. So again, what you see is a decline rather than some massive shift from the way it was before to now. And the decline in the criminal trial space is very evident when you start looking at current statistics about plea bargaining. Plea bargaining constitutes how cases are resolved about 90 to 95% in the state courts, and that variation has to do with across states or across areas of states. So the vast majority of all criminal defendants are offering a plea in order to resolve their case. This proportion is higher. I think it's in the 98% range for federal courts, so that there is just the vast majority of cases end in a plea. And again, that's not like that. It's really the word vast that has changed. The majority of cases used to be solved by a plea. What you've seen now is that the vast majority of cases are solved by a plea. What you see, particular erosion, is on the civil side. So this is one figure that was produced several years back. This is federal data, but I can tell you that state court data resembles maybe not exactly these numbers, but patterns are very similar. So this, the bottom of this graph goes from 1962, and it's again 50 years worth of data. And then what you saw is as population growth occurred in between the 60s and the 80s, you did see a kind of concomitant rise in both bench trials in the dark bars and jury trials in the gray bars, reaching a peak in the mid 80s and then decline. And basically this has stayed pretty stable. So we're at about 40 years of decline by this point. where the trial itself is highly endangered on the civil side. Now, it's possible that you're saying, hey, Mary, maybe it's just we're all getting along better and no one is suing anybody anymore. And so there's no trials because there just aren't that many more cases. And this is kind of the same data, thinking in terms of a percentage of all the filings that happen, and thinking about, well, how did a trial resolve that filing? And I mean, I think the picture is very clear that trials more generally constitute less than 2% of all civil cases. And in the state level, that's going to be around 2%. Jury trials then are a smaller percentage of that. So what we're losing in the last several decades is trials, is the act of having the thing we all see on TV, where two parties square off and try to convince an impartial and neutral decision maker that they have the better case. And there are, of course, many explanations for what's going on in the trial level, and what accounts for the fact that we've really let the trial wither. But I would argue that a lot of this is choices that we make about incentives that we offer to parties in both the criminal and civil side, as well as choices we've made to rein in the power of juries in particular, so that the cost-benefit analysis that people make when they're trying to decide whether to go forward with a trial is really shifted away, so that it just kind of doesn't make sense for people to pursue a trial except in the most unusual circumstances. So what do I mean by that? Let's begin with explanations that are offered on the criminal side. So first off, all that population growth that we've experienced since the 1980s, I don't know how many of you live in an area where there has recently been courthouses built. I know Austin made much of having built one 15 to 20 years ago, or embarked on that process. It was an incredibly complicated and difficult and expensive process, but we are not building very many courthouses, and we're not radically increasing the size of the judiciary, certainly at state and federal levels, so that just there isn't capacity for all the people who might want to have trials. But in particular, trials, when they occur, are very expensive processes. They're very time-consuming processes. So if you have busy judges who are barely holding their incredible caseload together, and somebody is exercising their jury trial right, you've just siphoned off an awful lot of people's time. It's also costly to have representation on the criminal side be able to match the state. You can probably find a public defender if you're indigent, but that public defender is juggling so very many cases, and isn't going to be able to give your case the kind of attention and care that would be necessary to go to trial and to manage their other cases while they're at trial. So everybody is dealing with the fact that trials are expensive and time-consuming. On the criminal side, what you saw in the 80s in particular was the rise of Congress and then some states enacting mandatory minimum sentences. And although I in no way would argue that the goal was to empower prosecutors, that's what it did. When you say, okay, with this charge, the bare minimum you're going to be able to get is you're going to be able to that you must impose as a sentence is this, right? And what happens in that system is that what the prosecutor decides to charge you with greatly affects your calculation as a defendant about what you're looking at in terms of time. And if we're doing mandatory minimums, then the judge isn't able to intervene a whole lot to say like, that doesn't sound fair, or I wouldn't give that much for this, etc., because the judge's hands are tied, right? And so this has made power move to the prosecutors, who are going forward and saying during negotiations, well, hey, I won't charge you with these 3 things if we can settle this, and that takes your expected sentence down, but I will charge you with this one, and we'll work towards the minimum. So it greatly empowers the negotiation process on the side of the state, and that strongly incentivizes people to plea. And that's because you're not necessarily looking at the minimum, or you're dealing in a case that doesn't have these minimums with discretion at the end of a trial. And it's well known that there is something called a trial tax or a jury tax in sentencing, which means even if the state offers a particular charge as part of their plea negotiations and sticks with that charge during your trial, the sentence that was talked about during plea negotiations is no longer the sentence we're looking at the end of a long, costly trial. Right? So if you are convicted at the end of a trial, you're looking at a judge being more likely, and a state being more likely to ask for a longer sentence. So that's just the way trials work, is that they impose a risk to defendants. So again, this is incentivizing people to plead. Both the uncertainty of a trial, as well as the fact that if it does go wrong for the defendant, they're looking at greater time. On the civil side, so very many reasons why civil trials have withered. There's the same explanations in terms of capacity and the cost of trials. And if anything, civil trials are extremely costly because there's this whole um, um, uh, uh, procedure of kind of discovery and turning over what you know and what you're going to argue, and there's summary judgment things, and so there's just all these paperwork that happens ahead of any trial. There is, because trials are so costly, there has developed, particularly on the federal bench, I have talked less to state court judges, but certainly on the federal bench, there is a kind of case management culture that has arisen that sees trials as a failure on their part, that they did something wrong by not getting parties to be able to plea. And that, again, is going to increase the pressure to settle. I said plea, I meant settle. It's going to increase the pressure to settle the case, and it's going to, you don't want to make the judge mad, right? And so it's going to increase the incentives. Within Texas and other states, there have been caps, legislative, and these were embedded in our Constitution, for medical malpractice cases, damage caps, which means that even if your case is meritorious and that you find a defendant liable, there's only so much that you're going to be able to recover, particularly on what's called non-economic damages, that we think of that as pain and suffering. So that you are going into settlement talks knowing that even if you're successful, here's a cap at what you're going to get. So if you're looking at a cap, why would you want to spend so much money on a trial that's just going to be, the cost of that is going to come out of your settlement, and particularly the non-economic side. And then finally, we've seen in the last 30 years a rise of what's called binding arbitration. And I recommend a really excellent series in the New York Times a few years back about examples of people who signed contracts or entered into employment where they were forced, by virtue of entering into that contract or that employment, to promise that they are removed, that they will not to agree that they will not go before a civil trial forum in order to get whatever complaint they have settled. That they say that you agree by entering into this to give up your Seventh Amendment right, and you agree to go before an arbitration panel. Typically, the arbitrators are hired and the arbitration company is hired by the person that you're suing. And so it is not this kind of thing that we saw at the founding, where we don't want a financial incentive among decision makers, right? Because how do you think about future business and still bring an impartial perspective to the case? And so, this out for companies has been claimed by litigators, for example, in surveys people have done of litigators asking, why don't you go to trial? And one of them is, well, there's a clause in this person's contract. I, jury scholar, put my father in a memory care facility. And in order to put him in a facility, I had to sign paperwork that says that any kind of malpractice or negligence cases that I would bring would go before an arbitrator. And, this is constructed in law as a choice. You don't have to go with that facility, but anybody who's been through that knows that that's not a word that you would apply to that situation when you find a place that's good. So I, of course, signed away my Seventh Amendment rights, but I would say any of you who subscribe to Netflix have already done this. In your terms of service, it says that if you have a complaint with Netflix, and here I'm not talking about, you got overcharged $10, but something that if there is something that's quite substantial, that you basically, by being a subscriber to Netflix, you have signed away that right. So this is something that this binding arbitration affects us kind of daily in contracts and agreements that we make. All right, so I just want to spend a little bit of time thinking about, okay, so we don't use trials so much anymore, and as a result, we don't use juries so much anymore. Is this something that we want to save? Is this an institution that we care about? And when I think about this question, I kind of think about it two ways. There's sort of a political interests and public support question about whether the jury continues to represent something that people care about. And then secondly, as a social scientist, I think about empirical questions about whether we see value in juries. So I'll just kind of walk through those before wrapping up. So one of the things I was thinking about in preparing for this talk is all the ways that juries sort of sit at one pole of several kind of controversies or struggles that we have in our society about the best way to do something, right? The way a system should work. And juries represent one way of approaching decision-making in a high-stakes conflict. So first off, one tension we see in any kind of system, and certainly one that we're dealing with now as we talk about things like government efficiency, is the tension between something being highly efficient versus something being very procedurally thorough, so that you really do feel at the end of the process that your claims were heard, that you had voice in this, that the system wasn't rigged, that everything's were fair. And the more we maximize that procedural thoroughness piece, the less efficient we're going to be, right? And so it's just costly and challenging to have the systems we have in place to give people a trial that protects their rights in the way. And we can make things go faster by cutting back on some of the things. Now, I'll say at the end that maybe there is a way through this tension that we just haven't come up with yet. But I think juries reflect a favoring procedural thoroughness over a very quick decision. And that's true when I've looked at juries. Texas is unusual for using juries in things like child custody decisions, if you opt for a jury trial, as well as removal of parental termination and termination of parental rights cases, you can opt for a jury trial in that. And one of the key findings where we've looked at judges versus juries in those cases is jury trials are really long. They're really long in part because you have to do so much to educate the jurors about the law and about what their decisions are, and basic terms have to get defined, and the witnesses have to explain things more, and that just takes more time. And any country that has developed a jury system, one of the things they say is both good and bad is that the litigators have to really up their game in order to argue to a jury, because they can't assume common knowledge. But it does make the process less thorough. I'm sorry, less efficient. Sorry. There's also a tension over whether we want experts to make decisions or whether we trust, quote unquote, the people, right? And that's a very common tension we are again working through in lots of contexts. There are plenty of places where I'm not going to argue that the jury is the right system. If I want to know if a drug is safe, I don't want a representative group of 12 people to have a trial to decide this. I want scientists to get together and have a system which allows them to have as much information as possible, not be shielded from, prejudicial information. I want them to have everything, and I want them to meet and discuss and bring their expertise. But that's a different kind of decision that we're making, and it affects a different set of people than the things that come up in civil and criminal trials. And so the jury is very much on the side of democratic input. Now, I could talk again for much longer about how many times there are experts on juries. It's actually quite a common situation, but in the main, we have opted with juries to have a broader cross-section and a more populist approach. There's tensions over whether you're selecting decision makers for some specific desirable characteristic. And here I'm not just talking about expertise, but a good citizen, someone who loves their country, somebody who is highly educated, someone who reads a lot, someone who's super not, whatever the desirable characteristic is, versus having a group of people who represent a broad swath of the community. And I can tell you that juries do not well represent the community in the sense of every characteristic we might want. They are better educated than the populace. They are wealthier than the populace. And there are racial disparities that are pretty chronic. But in the main, they represent a far wider cross-section of the community than most anything else you encounter in society. And that's one of the things former jurors will say to me. Like, I talked to people and I had to work with people I never would have talked to or interacted with in this setting. But we're not necessarily we've gotten rid of systems that we used to have where like people would be nominated to be jurors because they were such good citizens. We've moved away from that. I will say that the decline of the jury trial, and I'm not going to make a conclusion about coincidence or not, but it does coincide with historically unprecedented levels of jury representativeness. So I can tell you that juries are not fully representative today, but oh my goodness, how they compare to even 50 or 60 years ago is amazing, because courts have really, through prompts from federal and state law and the Supreme Court, have worked to get rid of a lot of the barriers to jury service, and we see a much more representative group. But at the same time, we're taking away trials. So it is interesting to me that that there is this. Okay. The other thing is just sort of, do people care? This is something that I've looked at in public opinion data. In a survey of Texas adults, we asked people to consider a bunch of scenarios and ask whether they would prefer a jury versus a judge in that setting. And just kind of one interesting finding is some variability among people who are they're not necessarily born in Texas, but they are citizens, English speaking, of varying races, compared with people who are not citizens and took the survey in Spanish. And what you see is the majority of people, if they're asked who's the most accurate, would you want a jury or a judge if you were a criminal defendant, if you were a plaintiff, if you were a defendant, what you see is in the first three columns, people who are kind of, you might say, socialized well and integrated well in the United States, the majority of them do prefer a jury over a judge, although there's variability even within those groups among people. It is non-white Hispanics across the board who feel the most comfortable with the jury system across all the scenarios. But even all of that variability compared with folks who were not raised in the United States and where the jury system is very unfamiliar, you're not seeing interest or support in that. A more recent 2023 survey of people found that people who served on a jury were particularly supportive, not just of juries more generally, but of court systems, of law, of police, that there's a correlation between jury service and kind of a support for the system. And then the other way to ask this question about juries, and I'll give this slide a little bit of time because it's a little complicated, but there have been people who have tried to understand, well, do we get different verdicts from juries than we would from judges? Do we need juries? Are they value added? And one of the earliest studies of this, which has been replicated, so if you're noting the year, which is as old as I am, there has been more recent data confirming this, but this is sort of the best quality study, so that's the one I report. They did a sample of 3,500 trials, and what they did is they didn't just look at cases where a judge decided and cases where a jury decided, because those are different animals, right? So to get the true apples to apples comparison that you want, they looked at jury trials and then gave a questionnaire to the judge and said, what verdict would you pick? What would you say this case merits? And again, complicated, but here we go. We can ignore the hangs thing because juries don't hang in very many cases and judges don't hang at all, right? So just know that about 5% of the cases there was no verdict to compare it to. Let's focus on the other 4 cells. And what you see here is 2 kinds of agreement. So this is where a jury acquitted and a judge would also have acquitted. That's that 13.4%. Here's where the jury convicted and the judge would have convicted. That's 62%. So put together those 2 percentages, in 75% of cases, the judge and the jury are agreeing. Now, I don't know if you look at that in horror and go, oh my gosh, there's so much disagreement. Or if you say that's a good thing, I will simply point out that if you contrast it with what could be otherwise, which is if it were 50% agreement, I'd be terrified because that means you could flip a coin. If it were 100% agreement, that would be really strong evidence that you don't need juries, that you could just get a judge and get basically the same result. And we're wasting time on trials and juries. And if that efficiency thing should start kicking in. But it's right in the middle of those 2 extremes. And again, this was replicated in the early 2000s. So we're seeing that kind of pattern again. And then final point I want to make on this is where they disagree, the vast, vast majority of those disagreements live in this cell right here in these criminal cases. The jury acquitted, but the judge would have convicted. So if you're a founding member writing a constitution and you're envisioning the role of the jury, this is what you were envisioning. This is what whether the jury is right or the judge is right, I don't know. But if the jury and the judge are going to disagree, the founders wanted it to be in terms of protections for the defendant. And it's the quite rare case where the judge was the more lenient one. Okay, so just to kind of summarize what we've been talking about, juries are envisioned to be a check on all branches of government, and trials, and therefore juries along with them, are vanishing and represent an extremely low proportion of verdicts. The explanations focus on costs of trials and a number of practices that incentivize pleading and settlement. The will to save this fundamental constitutional right is kind of unclear. It could be that people really want more efficiency, want more expert decision-making and elite participation, maybe. But I think it's also the case that the public may not realize that juries are on the decline, that this is news to a lot of people, and may not appreciate how often juries do agree with judges, but go their own way and represent a value-added system. And I just am always so heartbroken about the vicious cycle of the vanishing trial, because it means that fewer people get to see the jury up close and experience that. Broad ideas for reforms. I mean, I hate to finish the talk on I don't know, but it is, really a case of looking at the supply side issue and investing in more court spaces, literally, and more judges and more resources for people to have excellent counsel. On the demand side, considering ways to make trials more efficient. Maybe there are practices and limits we can do. We could limit time. We could limit, and there are some people who innovate that way already. We give power to the parties to try their cases. So anytime that you put limits, you're encroaching on lawyers' power there. But if it means they get a jury trial in a more predictable way, maybe there's something to think about with that. Address the culture of judging that considers trials failures rather than opportunities, and consider potentially political reforms to things like mandatory minimums and trial tax. And thank you.
Thank you. We've got some questions coming in if you're ready for them. Some of
Sure.
them
I would love
have
you
to
to give
do
them to
with
me.
point. Okay. You've kind of gone over a couple of these some of the time, but it's an opportunity to go in just to explore deeper. So
Yeah.
I'm just gonna read them off in order.
Okay, great.
All right. So has the judicial system ever considered working with behavior analysts to decide on what a sentence or a consequence should be, like embedding the matching law?
That's such a
You
great
know,
question. I mean, social scientists
yeah.
have a lot to say about sentencing. That's kind of all of the sociology of criminal justice things, and then certainly psychologists have thought about this. Um, uh, I would say that I think we um, overestimate how much prison is necessary to make somebody have a consequence. It's true in parenting as well. We often think you need like 3 months of, taking away your phone, and really it's remarkable how a short period would do. And I don't want to minimize the important justice features of sentencing, but you can accomplish a lot in terms of the messages that we send and the deprivation of liberties. Through, I would argue, quite a bit less than we do. And people think it takes more than it often does.
Okay. How has mediation affected the trial equation and your opinion of that?
I would say there's been a move to mediation, but that is all a piece of helping cases settle. I think the arbitration is the one that's kind of newer. It's existed for a long time, but it's really taken off. Mediation is where the parties do come together, and instead of the two lawyers talking with each other, there's a professional who's aiming to kind of can take a little bit more of a psychological approach as opposed to like a power approach, and see what each side really needs to feel good about concluding this case. Certainly on the family court side, that's been a huge area. But since jury trials, except in some pieces of Texas litigation, juries aren't used a whole lot there. I don't know how much they're encroaching in some of that. Employment law would use some mediation practices as well. So I don't have data, but I know that it is part of a culture of feeling that settlement is good. And there are cases where I agree.
Um, how can high costs and long times be reduced so that more people feel comfortable with going to a jury versus a plea or an acceptance of a deal that they don't think is fair? Yeah.
Yeah, I think on the criminal side, unless we address the kind of the very draconian sentences that are on the table compared with what
Yeah.
happens at a trial, that's going to be hard to intervene in. It is, I'm not a lawyer, and but I talk to defense lawyers who say they can't in good conscience encourage somebody in an iffy case to go to trial given what they would be facing, so that they themselves are encouraging them to take the plea, even if they know that client, if there's real doubt about that client, but it's not what reality is, it's what you can prove. And when the disparity is so extreme, the risk is just intolerable for people. On the civil side, I think there is more trimming you could do, and more judicial management of trial time, of the discovery process, of all the things that kind of run up costs, the number of experts you can hire, those kinds of things that, and I'm expecting to get blowback if there are any trial attorneys here that, that I'm advocating for judges to take a heavier hand because they already feel it. But at the same time, if we're looking at efficiencies, and it's between no trial and a somewhat more abbreviated time limited situation, I think, it depends on a lot on laws that I don't know the substance of, but judges I know have talked about that and try to figure out angles where they can incentivize parties to consider those limits in order to get the trial.
Yeah.
It's less of an
Um,
option. It would be less of an option on the criminal side because you can't take away their right to put on their case.
True. And one of your charts suggested that, although, juries are less frequent, this question is really about, the importance of juries being critical in the instances in which they are invoked. So it's critical to still have the jury option. It's really just, I think what we're hearing today is that you have to weigh all the options before you decide if you're going to go to a jury trial.
Sure.
75% to me, I see both sides. It sounds like, well, that's actually working pretty well, but that 25% is too large for my comfort, you know? So,
I get
um,
that. My students say the same thing.
yeah. So you discussed monetary limits per law. Do punitive damages override the monetary limits that legislators have written?
Uh, Great question. And punitive damages are a different category from
Yeah.
non-economic damages. And there are, I don't know my Texas law on punitive damages, and I apologize again to any people in the audience who do, but that there are definitely punitive damages have been one of those places that people try, that states will either try to cap, or they'll say, well, they're not going to go to the party that's suing their punishment, right? And so they should go to the state instead of to the party. And so I'm not going to be able to cite chapter and verse on punitive damages, but they are always very controversial. I will emphasize they're extraordinarily rare, because in order to get punitive damages, the conduct can't just be negligent. It has to have risen to this other level of having been basically completely reckless, and with an unreasonable amount of care taken. And I'm not saying that is, there's lots of instances where people are acting that way, but it is hard to get the okay to pursue this and to have a strong case for it.
Mm.
So they are rarer than people think. It's just they make the news because they're usually pretty big.
Yeah. Um, Back to kind of this idea of being efficient. How do you access the use or how do you assess the use of Zoom trials in terms of fairness, though? So in terms of fairness, do they work?
So a few were tried during the pandemic only on the civil side and only on pretty small bore things, just to kind of move
Mhm.
stuff along. There has been some talk about moving jury selection to a more remote venue so that more people could be considered and not have to make that trip down to the courthouse. On the criminal side, I just can't see a world where that's ever going to be okay. You do give up a lot by being on a Zoom call instead of in a courtroom. And you would worry a lot about jurors sort of uh, turning off their camera and playing free cell, or playing free cell and having their camera on. Just you give up control over their behavior. um
Mhm.
and so where I've seen it as like nipping at the edges of some things, or managing some pieces of the trial that potentially are just kind of, we could get through that quicker if we did it on Zoom. um I haven't seen a big move to make that kind of the modal way of deciding on civil cases.
Okay. Um, so what are your thoughts on judge shopping? So the idea that someone can shop for a judge that may be more preferential to their case.
I would not be opposed. I would not be opposed to having Congress for on the federal side,
Mhm.
and any state restrictions. And it really tends to be a more federal issue, of this idea that, it's one law. And so, I'm going to go file this in the Ninth Circuit instead of the Fifth Circuit, or alternatively, I'm going to go to this one uh, place in West Texas because I know there's one judge and I know that judge, and so I think that I don't, I have not heard a good defense of that practice. Because if you have a case, then ideally your case is one that convinces all kinds of judges, maybe not every judge, but if it should not depend. And I worry about the perception that it depends on the political nature of that court community, particularly when there's just one
Mhm.
judge, so you know what judge you're going to get.
And yeah, I'll just like that's I agree with you completely. We have one listener who they say that they didn't quite understand the point about unprecedented levels of jury representativeness. Is the jury more or less representative of the community than before?
Oh, yes. So let's
Yeah.
let's talk about the founding, right? White
Hmm.
male property owners,
Hmm.
right? So certainly we passed that bar now. That uh, actually discriminating on the basis of race was one of the post-Civil War You couldn't just write a law that says no Black people on juries. Now we know that it took 100 years to actually see communities stop finding other ways to keep Black citizens off of juries and Latinos off of juries. But women didn't have opportunities to serve on juries really until we got the vote, because so much of jury service is linked to whether you're a registered voter. And it took another 60 years to take away some of the barriers that states erected. And they weren't barriers, like the states wouldn't have called them barriers, but for many years, states would do things like say, women have automatic exemptions because of course they're at home raising the children. And so all they have to do is not show up and they won't be in trouble. And so women, being a rational bunch, often didn't show up to jury duty. So you would have these massive, like 70% male jury pools, right? And the Supreme Court said no to those kinds of practices and really moved in the 1970s to thinking about a fair system is basically a system where people can be randomly selected from lists. Those lists are not unreasonably biased, and that we try to reduce some of the barriers to people serving. We have not gotten where we need to be, but we are so much better than it used to be. And we got rid of things like intelligence tests. People used to have to pass a test about how much they knew about the law to serve. And I'm not just talking about the South. I'm talking about like my home state of California had those kinds of tests. And so we've gotten rid of those kinds of things. And as a result, juries are not fully representative. And I could show you the numbers, but they are so much better than they used to be.
Okay, I have to apologize to everyone. There's someone at my door and my dog is going nuts. So if you hear a corgi, he's very cute. He's just very loud. So sorry.
So,
The last question I wanted to include before we jump off is, this is a great question, and feel free if you're like, this is not my expertise, but the question is, why is the death row process so lengthy in many cases, and talking about decades in some of them? If you can give us any insight into why that process takes so long.
yeah. So I assume what you're talking about is from the time of a sentence, a death sentence, to the
Mhm.
time that it's actually carried out. And I think this is a really nice example of the efficiency thoroughness tension that basically anytime a death sentence is involved, there are just rights to appeal that don't belong to the rest of cases. And there are rights to have that verdict reconsidered, and that the process be uh, shown to have been the product of a fair process. And the overturn, like the rate at which death sentences are overturned is quite high. So reviewing courts do find reasons in death penalty cases to have a second jury hear the case and consider it again. So some of the delay is because people have more than one trial because an appeals court says that the first one was flawed. And so that's one piece of it, both the fact of appeals and the high rates of errors that you see. There have been, if you're following the news, a lot of restrictions from particularly Europe on not wanting their chemicals that they produce to be used in executions, which means states often are looking around for the states that have the death penalty, looking around for compound pharmacies and other places to have chemicals that they're going to use for lethal injection. Those then have to be reviewed, et cetera, and there might be protests against it. And I just think, there is a desire to get to a place where we're really sure that this is the person, that it's this person's, it's time to carry out this sentence. There are just a lot of hoops and issues that have to be settled. And if we were to make it more efficient, we would have to tolerate more error.
Well put. Yeah, I agree. So that was our last question. We are almost at time. So thank you very much, Dr. Rose, and to Extended Campus for bringing us such an interesting lecture today. Really enjoyed listening to you. And To our audience, don't forget to register for the April Lunchtime Lecture entitled Telling Stories with Sound from our very own Texas 10 winner and outstanding young Texas X, Corey Pereira. You can register now at texasexes.org/lunchtime lectures. And thank you again, everyone, and y'all have a great week.